had nobody to teach me. So I put this together to show everybody how it works, what it is. This is just a brief explanation. So I want you to know I'm not an attorney, I'm not a CPA, I'm not a paralegal. I'm an opinionated real estate investor who has studied land trusts, and I am a student of the land trust for years. And so if you have any questions, you need to talk to your attorney or your CPA before you take any action. Now I've done my disclosure. Fact, did you know statistics show that approximately 1 in 12 people in this country will be involved in a lawsuit this year? Statistics show every year at least 7 million slip and fall civil lawsuits are filed throughout the country, where many unsuspecting innocent people and their families will be party to those lawsuits that 85 to 95% are settled out of court. Most of these are nuisance suits generated just to get money. Fact, fraudulent lawsuits are a $5 billion business affecting many unsuspecting and innocent people each year. Do you want to be next? Are you going to be the next victim? I hope not. If you own all your properties in your own name, you know what is hanging out for people to come after what you have. Are you a target for a lawsuit? Take this simple test. Are you in business? Do you have employees? Do you have a teenage driver? Do you own property? Do you manage property? Do you drive a car? Do you have assets others are envious of? Are you considered a professional? Do you have a steady income? Just to name a few. If so, you are a target for a lawsuit. You see, there are many people in this country that use the courts to steal from good, hardworking people so they don't have to work. I have a problem with that. I don't think it's right. I don't think it's fair. So to me, it's better to hide your assets so others don't know what you have. Just food for thought. My goal is to make the task of suing you more difficult. Just because someone may assume you own a particular property, I want to make it very, very costly and time consuming, getting few results to find out you don't own any property. One thing every real estate investor needs to know: own nothing, control everything. The land trust will allow you to do just that. Your name won't appear in public record. Years ago in the 80s, I was working at the Upjohn Company in Kalamazoo, Michigan, pharmaceutical. And I worked with a guy by the name of Chuck Bennett. Chuck Bennett told me his dad was the trust attorney for the entire Upjohn family. And I said, "Oh, what's a trust?" And he said, "You know, I'm not sure what a trust is. All I know is my dad said the entire Upjohn family own nothing, but they control everything." I thought that was very important. I didn't know what it meant. I just knew I wanted to know more about it. Well, there was no information available until I moved to Florida. In Florida, we are lucky because the state of Florida has a specific statute about trusts, land trusts specifically, that we can make reference. Can somebody get this door? That we can make reference to know exactly what we can and can't do. So now that you understand own nothing, control everything, I'm going to go over some of this stuff and let you know that it's simple to do, easy to do. You can do it. I don't care where you live. So what is a trust? A trust is a written arrangement whereby property is transferred to a trusted third party, the trustee, from the grantor, the seller. A trust is any kind of a contract between a trustee and a beneficiary. So everybody thinks a trust is some kind of legal phenomena. No, it's a contract between the trustee and the beneficiary. That's the definition of a trust. It's a contract. A land trust is a title holding trust only. It only holds title to the property. It owns nothing. It holds the title. A land trust does not have any other assets than the trust property. I believe you should put each property in a separate land trust. I get asked many times, what does it cost to put a property into a trust? A land trust is 4 pages. How many pages in a ream of paper? 500. Divided by 4, that means I can do 125 land trusts for $6, plus the price of a printer cartridge. Now, years ago, when I first came to Florida, I bought 10 houses in 1 week. My group bought 10 houses. I did the paperwork, but I had to hire a paralegal to do the land trust. That paralegal charged $600 for each property. So they spent $6,000 for all of those land trusts on those properties. One Saturday, it was raining out and I'm sitting in my office. I had the folders on my desk. So I picked up one of the folders. I opened it up. Here's the trust. I read it. Didn't understand much about it, but I read it, start to end. And I set that down. I picked up a second one, started reading it. Something strange about it. It was almost identical. The only thing different was the grantor, the trustee, the trust number, and the legal description. So I picked up the next one. Same thing, picked up the next one. So I paid $600 to have a document printed out with just a few different things. So I made up my mind right then, I'm going to retype that into my computer. I'm going to do my own. I can do them. It's a contract, isn't it? It's a contract. So, because I had the verbiage of a properly written Florida trust, I retyped it. Wherever something needed to be filled in, I put a line. So after that, when I would create one, I would put my cursor on the left side of the line, delete it, and type in what went there to make it look professional. Been doing them ever since. Now, I've studied them. I've taken classes on them. I know the attorney that helped write the Florida statute on land trusts. I have his book. My land trust course is based on his book. What I have is I have information on all 50 states in my course, so that it tells about anything specific, any statute in your state, even court cases that if you ever get into trouble, your attorney can use as reference to look up what happened. Anything unique about your state and their requirements. So I believe you should put each property in a separate trust. A land trust doesn't have a bank account. See, here's where the attorneys get screwed up. 99% of the attorneys I know think a land trust is a living trust. A living trust, in most cases, the people that have the trust, they are the trustee and the beneficiary. Well, the land trust is not that way. You can be, but I don't think it's a good idea. I would rather use somebody other than a family member as my trustee. I could have one of you be my trustee. Could you sell the property? You own it. Yes, you could. But what I do is I trust my trustee, but I also put things into place. So if you try to sell the property out from under me, I'm going to know about it. Very, very important. A land trust is not a living trust. A land trust is a title holding trust, a hybrid. States that do not recognize land trusts usually allow some type of real estate title holding trust named other than a land trust. For instance, Massachusetts, what we consider to be a land trust, they're called nominee trusts. But it's still the verbiage within, not the title at the top. So could I call mine a living trust in title, but the verbiage within is a land trust? Could I do that? Yeah, I can name anything I want. Would that throw someone off that was coming after you for money? If they looked, say the deed is the only thing that gets recorded. The land trust, once signed and notarized, is quickly put into your safe and locked in there. Nobody can see the trust. Understand that?
So the trust isn't recorded anywhere?
Trust is never recorded. Now, banks want you to record it. Title companies want you to record it. And the answer is no. Because it has the beneficiary's information on it. You don't want to divulge who the beneficiary is. That's the purpose of the trust. So nobody knows who owns the property. Actually, the trustee owns it, but it's for the benefit of someone else. What is title? I said it was a title holding trust. Title is evidence that the owner of land is in lawful possession of that parcel, evidence in a deed. So it's just your name in a deed. It's what title really is. Now, here's what took me 7 years to learn and understand. Every land trust only holds the title of the property. Every land trust has a trustee who owns the property in most states. Every land trust has a beneficiary who only owns an interest in a trust and does not own any real estate. You see, the verbiage within the trust document converts the beneficiary's interest in real estate into personal property. Now, that may be a little bit confusing. It just says that their interest in the land has been converted into personal property. Personal property can be transferred at any time. So we'll get into that a little bit more in a minute. The land trust only holds title. They have a trustee. They own the property. So what is a trustee? A trustee is one, a person or entity that holds property in trust for another to secure performance of an obligation. The trustee holds the property for the benefit of another, the beneficiary. So every land trust has a beneficiary who only owns an interest in a trust, does not own any real estate. What is a beneficiary? Beneficiary is the one that receives the benefits, profits, and avails from the trust asset. Now, they get the money. They pay the taxes on the money they get. Okay? The trustee doesn't get the money unless they don't make arrangements to give it to the beneficiary. But whoever receives the money from the trust asset claims it on their income tax and they pay the tax. Here's how this works. Whoever receives the income claims the income on their income tax and pays the taxes. So you want that to pass directly to the beneficiary. This is you. This is you and your lovely family. All right? You're the beneficiary. You put up a wall of privacy, the land trust. Because nobody can see behind that wall of privacy. You have a trustee. They're out front. They're the ones that are trying to keep everybody in the world from knowing who the beneficiary is. And they're out there trying to protect you from the trip and fall scumbag's attorney. You recognize this attorney? So this picture kind of explains it. Trip and fall people hire an attorney. They have to come over and sue the owner of the property, who is the trustee. They try to get the trustee to disclose who the beneficiary of the trust is. Now, the way I set mine up, the trustee takes direction from the beneficiary, but they don't know who the beneficiary is. See, we do things on purpose. Why is that important? I don't want my trustee to have to be subpoenaed, put on the witness stand, and lie and say, I don't know who the trustee or the beneficiary is when they do know. By doing it the way I do, they can legally, morally, and ethically sit on a witness stand and say, I do not know who the beneficiary is without perjuring themselves. Yet, that's a secret. No, I teach that at the boot camp. We go into great detail how to keep the trustee from selling the property, how to keep the trustee from knowing who the beneficiary is. It's pretty simple. Are land trusts legal in every state? A land trust is a contract between the trustee and the beneficiary. Last time I checked, contracts are legal in every state, no matter where you live. Therefore, the land trust is legal in every state. Now, some of you are going to be told by your attorney they're illegal here. No, they're not. It's just they don't know how to monetize them, and they don't know anything about them. See, it's not a big money maker for them. So they're not going to take the time to learn. Understand that? I have not found very many attorneys. They say they know. I found very few attorneys that truly understand how the land trust works. Why do you need to use land trusts, and why are they so important? When you own real estate in your own name, you have given any contingency fee attorney and their trip and fall clients a roadmap to where all of your treasures are located. You see, every one of you, I can go to the courthouse where you live. I can pull up your name. It will show me everything in real estate you own. It will show me income streams if you're accepting monthly payments on notes, because everything's in your name. Bingo, I got you. If I can sue you, you can't say, oh no, that's not mine. So if your name never appears in public record, do you have an advantage? You see, I may assume that you have property because I've seen you at that property. You're my landlord. I've seen you work around there. I've paid you rent. I know you pay the taxes on the property because I checked. Does that mean they're the beneficiary? No. And you will never know unless you read the last page of that trust that's locked up in the beneficiary safe. So anybody that assumes who a beneficiary is doing exactly that. They're assuming, but they don't know for sure. So they have to sue, bring in the trustee, try to get them to tell who the beneficiary is. That's why we put that stopgap in there. A family lost every one of their income properties owned in their name, thousands of dollars in court costs because their drunken neighbor decided to take a swim and drown in the pool of one of the investors' vacant rental properties pool that was surrounded by a 6-foot-high fence. Their liability insurance policy was inadequate to pay the full amount of the claim. I was told of this where an investor bought a house that had a pool. He tried to do everything right. He put up a 6-foot-high factory fence, you know, the crisscross. Well, on the top, it has those barbs. So what happened apparently, after they put the fence up, the neighbor had a few too many toddies and decided he was going to go for a swim. Apparently, he'd been swimming in that pool every day. But he climbed the fence, I'm told. His pant leg caught. He was drunk. He flipped over the fence and hung because his pant leg caught on the top of the fence. And he hung there. He was drunk. Eventually, his pants ripped and he dropped on his head, knocked him out. He rolled and fell into the pool and drowned. Now, didn't the investor try to protect himself? But he lost everything because he didn't protect himself enough to keep the person out of the pool. Bad, bad, bad. They knew exactly who owned it because this investor apparently owned all of his properties in his own name. So they knew exactly what they could go after. They could figure what he paid for them, what his mortgage balance was, how much equity he had. They went for not only the insurance, they went after everything the man owned, wiped him out. Years of work wiped out. So
You always go back and put your properties in trust.
you can. Yeah. So this was a story that kind of horrified me. If you own any properties and your own name, statistics show you've got a huge target on your back the size of Kansas, and a damaging lawsuit could be just around the corner if you don't do something fast to prevent it happening to you. As a trustee for someone else, I have been drug into court. I had to go in for a 4-hour deposition. In that deposition, the attorney for the trip and fall person asked me a bunch of questions. The trouble is he asked the wrong person. Just a little food for thought here. You see, there was me at that time as a property manager. I was contractual with a company. There was me as trustee. And there was me personally. Every question for 3.5 hours was asked to me personally. Me personally had nothing to do with that property. Me as trustee did, and me as corporate employee did, but he asked the questions to me personally. I had nothing to do with that property. I waited for 3.5 hours before I asked to make clarification in the record, and I wanted to put it in the record so a judge wouldn't say, well, he's lying, playing games. And I was right. See, I was one of those 3 legal people there, and I had nothing to do with the property. If they would have said, Mr. Harbolt, did you as trustee do anything? Or did you as a property manager do anything? I would have said yes. I answered no to all the questions. Now that attorney was very, very upset. And he wasn't going to go through that again. He asked me questions like, did you ever collect rent at that property? No. Did you ever do any work at that property? No. And that type of questions. I never did. I as trustee did. I as corporate employee did, but I personally never did. Do you understand what I'm saying? We are separate legal people depending on who we are and what we're connected with. Just because you're you, if you have a corporation or an LLC, and if you're a president of the LLC, that's one thing. But if they're coming after you personally, you have no responsibility. In a court case, they will come after you personally, just in case you might have a personal interest. But they have to come after you as the officer of a corporation. The 4 main reasons we use land trusts. Number 1 is privacy. The land trust in and of itself is not asset protection. Now we can do things to make it pretty close to asset protection, but just having it in land trust is not asset protection. Understand that. But what it's doing, it's hiding the asset. It's not hiding the asset, it's hiding the beneficiary of the asset. Very, very important. It avoids property being probated. Upon your death, if you are the beneficiary, if within the trust you name a contingent beneficiary, at the second of your death, that contingent beneficiary, whoever it is, owns the beneficial interest in the trust. Now, sometimes people don't know. But what I recommend is if you do a trust, in that I have a sheet that when you come to the training, you get this sheet that you put all the information, who the trustee is, the beneficiary, the addresses, everything. Put that in the folder so if something happens to you, someone can unwind it. You'll know who the players are. It's critical. If not, did you ever hear the story about W.C. Fields, the old vaudeville comedian? He didn't trust banks after the Depression. So every city that he performed in, he got paid, he deposited money into a bank account with a fake name. Then he died. Nobody knew where that money was. No, it was never recovered. So you have to leave a way for a family to track down where everything is located and who is in charge after you're gone. Ease of transferability using one simple form. With the land trust, I can assign my beneficial interest using a one-page from me to whoever I'm assigning it to. They are now the beneficiary. Simple, easy. You can change the trust every 5 seconds if you want. You don't need attorney. You pull out your trust, you go to the beneficiary page, you cross out the beneficiary. On the next line, you write somebody else's name or an entity. You don't want that anymore, you cross it out. The next line, you write something different. It can be changed every 30 seconds. Does not need an attorney to do it because it's your contract. It's up to you to put on it what you want. Judgments attached to the property do not attach to the beneficiary, only the property, because no one knows who the beneficiary is. So if you have a property and it has code enforcement, liens, or judgments, it doesn't attach to your name. If it attaches to your name, it's going to be on your credit report sometimes. You know, it only can attach to the property, which means you can't sell the property without paying off those liens or judgments, but it doesn't attach to you because when they put those liens on the property, they have no idea who the beneficiary is. And the trustees held no liability. They're indemnified by the beneficiary. They have no liability just for being a trustee. Now, I made this drawing so you can understand how you buy a property into a land trust. You or your trustee write an offer to purchase a property using a purchase agreement that names the trustee as the buyer. This is how you buy one. Now you have 2 ways you can do it. If you're dealing with a seller, he doesn't understand, I may buy it as Larry Harbolt or assigns because they know me. As soon as they sign my agreement, I will assign the contract to my trustee, have my trustee prepare the trust. Or I let the buyer be the trustee. Either way, the trustee is the one that has to go to the closing. They're the buyer, they're the owner. And when it comes time to get rid of the property, they're the one that has to sign the papers when the property's sold. They're the owner. They have to state who gets paid at the closing. An interesting thing about trusts, to be funded, they have to have an asset in them, like a house. But when you sell the house, the second the deed is signed, that you're deeding it out of trust, the trust evaporates. It no longer exists because it's defunded. There's no asset in it.
So who gets the money?
That's whoever the trustee designates and gives that person's ID or social security number. To what?
To the attorney.
Why is an attorney involved here?
Well, in North Carolina, most of them.
Oh, you use an attorney? Yeah, we use title companies here. When you come to the class, I have a page from the attorney to the title company saying, I do not receive any of the funds from the sale of this property, the fund that make the check out to, and they give somebody else's name. And at the closing, that person has to collect the check and give their ID number. Now, once your offer is accepted by the seller, you can take the signed purchase agreement to your title company or closing attorney to start the closing process. At the closing, the seller will sign a warranty deed, which once signed transfers ownership of the property from the seller to the trustee, who is the buyer. Before the closing, the land trust agreement is prepared and signed by the beneficiaries and the trustee in private, then is placed in the beneficiary's personal safe. The property is then titled in the land trust where the trustee owns the property and the beneficiaries do not own any real estate, simply own an interest in a trust. Yes. Yeah, all of this is in the class. I'm just showing you how it works here. So here is a real estate agreement. It's pretty simple. The trustee's name goes there as the buyer and the seller's name. The trustee signs the purchase agreement and the seller signs the purchase agreement. The warranty deed to trustee. The seller's name goes as grantor to the trustee and the legal description, the main thing. Second page, nothing. Third page, I name a successor trustee in the deed. So if my trustee disappears, I've got somebody named. And then the grantor or the seller signs the deed. The land trust agreement. The trustee's name goes there. Legal description. Second page, nothing. Third page, the beneficiary's name. And at the bottom, the trustee accepts their duties. Now, how to put a property you already own in your own personal name into a trust. You already own this house in your name. Next, you deed the property into a land trust, which names a trustee who will be the actual owner of the trust property. Once signed and notarized, you then take the warranty deed to the courthouse and record the deed in public records. Next, you prepare a land trust agreement. Then once prepared, you never record the land trust agreement. The land trust agreement is a private document which should be kept in the beneficiary's personal safe where nobody can see it, ever see it, you can get a hold of it if you need it. Simple. Takes a deed to transfer it. Warranty deed to trustee, land trust, done. A doctor in Pennsylvania was sued and lost his beautiful 10-acre ranch owned in his personal name plus millions of dollars because a teenager supposedly hurt his neck swimming in the doctor's ranch pond. The doctor had no idea of the injury, and over 30 days later, when the doctor was informed of the injury, turned in the claim to his insurance company, who refused to pay the claim because it was filed over 30 days from the date of the incident. He ended up losing it all. What had happened, every year he had the youth from his church come to his little 10-acre ranch and have their summer picnic. That year, one of the girls brought a boyfriend, and they were in the water playing chicken. Everybody knows what chicken is. Well, apparently he hurt his neck. The story goes that 30 days later, he filed a $10 million lawsuit against the doctor because he was a high school football superstar. He had been contacted by scouts from professional teams. So he was suing because he had soft tissue damage to his neck that can't be proved. And he was suing for lost wages because he could never be an NFL superstar. That's how ridiculous things are. Well, the court of his peers decided he was deserving of that money. So he won. The doctor had to liquidate to pay off the claim. The insurance didn't cover it because his insurance policy said any claim must be filed within 30 days of the incident or it's null and void. They didn't get the claim until after 30 days, after the guy had taken some tests. So the insurance company said, we're not paying. Say what? Can't hear you.
That should have been reason enough for the doctor to win.
No, the doctor is liable. The rich guy is always liable. The poor guy, when you stand like in an eviction court, you're the rich landlord. This is the poor victim tenant that don't pay their bills. Most courts, unless you have perfect paperwork, are going to have sympathy for the scumbag that don't pay their rent because you're rich, you can afford it. I evicted a tenant once. I did everything by the book. The tenant did nothing they were supposed to. The judge gave them an extra 30 days in my house to find another place to live without paying. Justice? Yeah, tell me about it. The rich guy always loses. in most cases. That's why paperwork is so critical. That's why not owning it in your own name is critical. Now, this was the story I was told about. Why not just buy a property in the name of a corporation or an LLC? See, most attorneys tell you put your properties in LLCs. Why would they do that? They create the LLC. Don't they get paid to do that? Do they tell you, well, each one of these LLCs, you have a separate tax return on every year? Is there a cost to that? Is there a filing fee with the state on every one of them? Sure, but they don't care about that. They get paid to create the LLC. That's what they do. So the LLC, depending on what happens, is not asset protection either. The best that an LLC can do is have a charging order that you can foil whoever has the judgment against you. You can withhold money from them to the point that they come to the closing table and want to negotiate a better deal. But the LLC and the corporation, I've heard attorneys tell people, or I've had people tell me, their attorney said, well, put 10 or 15 properties in each LLC. Oh, that's real smart. So there's a lawsuit on a property. They find out the LLC owns 15 properties. Bingo. Cash reward. No, no, no. Just like with me, I don't want an umbrella insurance policy. Why? If you've got 15 properties that you've worked hard for under an umbrella policy, and there's a lawsuit on one, if they can go into that policy and find out there's 14 other properties, is there the slightest chance that the same beneficiary owns all 15? Absolutely. Cha-ching, here we go. See, if I go into public record and find out you've got 15 houses, I know what you paid for it. I know approximately what they're worth. I can figure out how much equity you got. Guess where I'm going to trip on your sidewalk? And guess what I'm going to do? Soft tissue damage. I'm going to sue you. I'm going to sue you for everything I can. And you can't deny it because you own the properties. So I can take them away from you. Yes.
I have my properties in a land trust, and I recently changed insurance companies, and they put the policy in the name of the land trust. And I asked them, could they put the mortgage on the policy also? And they were able to do that. But like if the house burns down, they're going to issue the check to the land trust.
And the trust doesn't have a bank account.
Right.
No. The insurance should be paid to the owner. Who's the owner of the house that you own in your own name? You. You're the insured party. In a land trust, the trustee is the insured party. Insurance companies don't understand that. I work with an insurance company that insures trusts all the time. They get it. You insure the owner, the trustee. You insure the lender as additionally insured. You insure, you put in the words, and the beneficiaries as their interest may appear. Now you've covered everybody. So why not buy it this way? You can buy a property in the name of a corporation or an LLC. Why not add another layer of secrecy to the mix to make it even more confusing and difficult for anyone or their attorney to find who actually owns a property if they have plans to sue, hoping you will give them something just to go away? See, most nuisance suits, they trip, they wrench their knee, whatever. They sue you for $50,000, hoping your insurance company will give them $30,000 to go away. That's what happens. It's a business. You see, if I was that type of a person, do you know who I'd go after? The people that have these extended cab trucks that have that bumper hitch in the back that has with the ball on it. I would hit my leg on that every time and sue them. Why? Because I mean, right there, bingo, you got the license number, you can check with the state and then go after everything they've got to cover your soft tissue damage. That's how people do it. I talked to a man from Michigan. He said, I don't need any land trust. I got a $3 million liability policy. And I said, well, let me ask you a question. If you rent your rental house out to a nice family, and God forbid, in the middle of the night, a fire breaks out and a family of 5 burn up in that fire, is there going to be a lawsuit? Let's say they sue for $10 million and win. How good is your $3 million liability policy? Why not hide your other assets? See, I make sure I'm never a trustee or a beneficiary. Why? Because in court, they're going to ask me, do you own any beneficial interest? No. Do you own any trust? No. I want to make sure that I can, without perjuring myself, but that don't mean I don't know where the money goes. Yes.
Is it true that you should put your personal residence in the land trust?
In Florida, I don't think so. My own personal opinion, because of our homestead law, in Florida, it's better to put your property in your own name, because in Florida, they can't take your home away. That was why O.J. Simpson bought a $12 million house in Miami. He protected $12 million worth of assets because after he got in trouble, they couldn't come after his home. But according to Walter, he read about a year ago, he lost the property for back taxes. It was sold because he's in jail. So in Florida, in your own name. I don't know in South Carolina. You need to check to see which is better. If you don't have homestead law that says that they can't take your home, you may want to put it in a trust. So the LLC and the land trust give you 2 levels of protection: anonymity, privacy on the land trust level, legal entity protection on the LLC level. In other words, nobody knows you have anonymity in the land trust, and the beneficiary can be the LLC, which gives you protection on that level, depending on how you do it. I can show you in the class how we can stack things so that it's going to be numerous lawsuits somebody's got to pay for to come get you. And it's all done with sheets of paper. Tax implication of a land trust. According to the Internal Revenue Code 677, a properly structured land trust should be classified for income tax purposes as a grantor trust on your income tax. If so, all income deductions flow through to the beneficiaries in amounts proportionate to their respective interest in the trust estate. We never use land trust to avoid paying taxes we legally owe. Some people say, well, I'll put my stuff in a trust and I get out of paying taxes. Wrong. That'll get you a trip to the Gray Bar Motel for an extended period of time. That's not what trusts are for. The land trust is used for privacy and estate planning. Now, I've got a course on land trusts. It has a document CD and it has an audio CD. It's a 160-page manual using land trust for your real estate assets from Lawsuit Happy America. It has 1-hour audio CD. It's got a 1 land trust document CD that's got all of the documents you need: the trust, the deed, the assignment, all, the letters, all different stuff you need. Comprehensive tax strategies using land trust. Now, what I give you is I give you 2 copies of a drawing. One you give to your CPA, one you give to your attorney. Let them set this portion up. It gives them a diagram how you can set it up so nothing shows on your personal tax return. Now, why is that important? If you ever get sued and you lose, most attorneys will subpoena your tax records for the past several years. If the properties show on your tax return, then they're going to go after them and they're going to get you for perjury. So you don't want anything pertaining to the properties on your personal tax return. These drawings show them how to set it up so it never shows on your tax records anything to do with the properties. That right there could be worth a lot if you own a lot of properties. Understanding that. Anybody see any value in that? No, I'm just put them on my own personal tax return, put them in my own name. Yeah. Hey, it's never going to happen to me. So you lie and you say, oh, no, I don't own any properties. They subpoena your tax records. Now you go to jail for 3 years for perjury. I don't think that's good. And then they take the properties away from you because you really did own them, and they give them to people that didn't work for them. What I just told you could be worth a lot of money to you. I give you those drawings, and they're not cartoons. You give one to your CPA and one to your attorney, they got to be accurate, but it just shows you can get the money, but nobody knows where it come from. The profits and avails from the property. It's that right there is worth far more than what this training costs. Here's an example. Washington. Every state I do one of these on. In the state of Washington, they have no land trust statute. Other Washington statutes that might affect land trusts, I found none. Washington land trust court cases. Here's 3 cases that if you ever got in trouble, your attorney could use to do research for you. For the land trust to be valid in Washington, the trustee must have some duties, such as to distribute the property or to pay the taxes. They have to have a duty. Unique Washington land trust details, found none. But every state, all 50 states, I do one of these in. So no matter where you live, you know what you can and can't do in your state. I also give you this package to give to your attorney. They're going to ask you questions you don't know the answers to. So instead of you answering questions, make a copy, give them a copy of this package. In it is a letter from me telling what you're trying to accomplish, some of the different things that the land trust does, and a copy of Florida statute 689.071 for their review so they get an idea of how the trust works. The land trust really got its foothold in Chicago back 100 years ago. Chicago, the Illinois type land trust is what we use. So understand that that copy can give them an idea. So you give them this package. Now you don't have to answer their questions. You also get a package to give to your CPA. It's a tax return done by my friend Leslie Jones, who was an expert on she was a CPA for properties, multiple trust properties. She did a sample tax return. It has that sample tax return in it that you give, and the 2 drawings, one to the attorney, one to the beneficiary or the CPA, that you give to your CPA. So you don't have to answer any questions because you don't know the answers. I give you both of those package with it. I give you a laminated sheet that's a quick study of the pertinent things you need to know about land trusts. That comes with it, plus other stuff. I do a 3-day land trust class in this room. I do it every few months. It's for 2 people, the price. You can repeat forever for free, and you get all the bonuses. So if you don't get it the first time, I've got people that have come back 4 and 5 times. That's okay. They're getting pretty good at it. They don't need my help anymore. I give you all the documents, and here's what you're going to do in the class. At the end of the class, I'm going to give you a package. In that package, it's going to be a hypothetical scenario. From that scenario, you are going to fill out a warranty deed to trustee. You're going to fill out a land trust. You're going to fill out an assignment of beneficial interest. and you're going to sign fill out a quitclaim deed to trustee, because those are the documents you're going to need. With this package, you can take it home because it tells you in that package what goes on each line in the document. So when you get home, you can do your own. If you have any trouble, you can call me. I'll walk you through what you got to do. I just had a call the other day. People were confused. They wanted to do homestead status on a property in a land trust. I walked them through it. They went through, I gave them the language to insert. It was fine. I charged $699 for 3 days of land trust stuff. My specialty is I have 25 ways that if someone is suing you, to keep their attorney chasing after ghosts and the person suing you writing checks to their attorney. We do things on purpose. And that's my goal. If you want to sue me, I would love to bankrupt you. I would really feel good about that. So by knowing you can keep their attorney chasing ghosts, running into dead ends, what's that worth to you? What is it if you went to an attorney to do a land trust? What's it going to cost you to have them do one? And it's not going to have in it what we have in this package. See, we put 3/4 of the corpus of the trust in the deed. The reason we do that, that's recorded in public record. That has the powers and the duty of the trustee. So it's there for the world to see. That way, I never have to pull the trust out of the safe to show the powers and duties of the trustee, because that has the beneficiary's name on it. We do things on purpose. It's a way of keeping these people paying an attorney, and believe me, it works. So we do that. 2 people, $699, repeat forever for free, and you're not going to beat the price. My boot camps, March 25 through 27, in this room, July 15 through 17, November 11 through 13. For the price. Now, there's others out there that sell a land trust course, and they get almost $1,000 for just a book, doesn't include 3-day training. This class, I have attorneys take because they got very little training on trusts when they went through law school. And this is a hybrid trust. Now, the attorneys that come through this class are real estate attorneys that promise me they'll never use it to harm investors. They will only use it to help investors. So it's good. I love to have attorneys. It's for 2 people. Bring your attorney if they would come. Bring your CPA if they will come. I welcome those people to come to the class. The people that helped train me gave me good advice. One of them was the assistant several years ago to the governor of Florida, the attorney. He's kept me giving out great information. It's legal, it's moral, it's ethical. And so what you get is good information. You can use it, you don't have to. The thing is, when you buy a property, get it in a trust. That's good enough, but I'm going to teach you how to bury it 20 layers deep if you want. Because see, I like to do that because it's all just paperwork. It's up to you what you want to do. That's the dates. It's $699 for 2 people. Tyler, if you're interested, get signed up, because here's what we're doing. We're going to put this out on the internet. This class is going to fill up fast. If you want to do it, sign up now. It's not a lot of time between now and then, and we will fill this class. There's no doubt about it. So if you want to do it, talk to Tyler. He can take care of it. He can deliver the manual to you electronically. If you want, you can get a hard copy. It's a few bucks more. Each couple gets 1 course. If you want a second course, if you bring a business partner, it's $125 for the manual, the CDs, and the other packages. So if you're interested, I'd love to have you, but you need to get signed up because this is going to fill up fast, that I guarantee you. So anyone have any questions? Todd?
You go into Then into living trusts.
I show how to use, I've got another course on personal property trust. And I show you how to use personal property trusts. They make great beneficiaries. Just another layer. Anyone else? You totally understand land trust now. You will when you leave the class. But then you're always going to have questions after you leave. So you can always call me.
Could you, there's a slide you had that goes over the process. You have the existing property that you want to transfer into a trust. The steps on how you do that again. It's about 8 slides back there.
Well, let's see what we got. I'll be happy to put it up.
Yep, there it is. About to come up there.
A lot of times my broad shoulders get in the way. Oh, sure, you're going to take a picture, aren't you?